Good morning. Welcome to the Appeals Court. I'm Justice Mead. With me today are Justices Hirschfang and Toon. We will be the panel for all the cases that will be heard today. If you haven't been here before, welcome. If you have been here before, welcome. Each side gets 15 minutes. You needn't use all of your time. We do not entertain rebuttal. We have read everything. My best advice is to get right to the point. So with that, I'll call our first case, 2019 P 1713 Commonwealth versus Martin. Mr. Shala.
Good morning. Attorney Stephen Shala for Mr. Martin. May it please the court. The lower court erred in this case basically for two reasons. The first reason was that there was insufficient evidence that Mr. Martin possessed the drugs. And if he did possess the drugs, there was insufficient evidence that it was for distribution. Secondly, the motion to identify the confidential informant should have been allowed because the confidential informant was acting as an agent of the police and not as just a mere tipster. Getting to the possession part, the law has been clear on this for a long time. A defendant has to have knowledge of the contraband. Knowledge can be proven by circumstantial evidence. The defendant has also have to possess, and possession can be either actual or constructive possession, and possession can be also joint, and that can also be proven by circumstantial evidence. Looking at the facts, the police testified when they arrived that Mr. Martin indicated he did not reside there. When he was there, he said to the police, he shared the rear bedroom.
I'm sorry, did you say he did not reside there?
He did not. He told the police that
he stayed in the bedroom, though.
When he was there, he stayed in the rear bedroom. That is correct.
There was documents in the bedroom addressed to him, mail.
That's correct, Your Honor. Right. Basically, the residence belonged to that of the female that was there, as was indicated by her name was on the mailbox, and she also had an electric bill in her name. He then correctly pointed to the police where the rear bedroom was. They asked him, are there any drugs or guns in the presence? And he said no. And he said he stayed there, and he stayed in the rear bedroom with the female there, and he even directed the police to the rear bedroom. He said, down the hall and to the left. So he was as honest as he could be insofar as where he was living.
Well, he wasn't honest about there not being drugs there, though.
Well, that comes under knowledge. What was found there were drugs. Drugs were found in a bureau with, I believe, with men's clothing, a shaving kit. Drugs were also found in a bag in a closet. Okay, so there's no doubt about that. There were drugs there. That's no issue whatsoever.
Men's clothing and a men's shaving kit.
Men's clothing and a men's shaving kit. Also, I think it's important to note, Your Honor, that there were also two children there. One of the children belonged to Mr. Martin himself. We don't know who the other child belonged to. Getting back to the bedroom, there were men's clothing there. What was not looked at by the police, first of all, there was no fingerprint evidence on anything. No fingerprint evidence was taken. No DNA evidence was taken. And most importantly, nobody matched the size of the clothing with Mr. Martin. I believe the record reflects that Mr. Martin is 5'10", 250 pounds. It didn't take much to check the clothing to see if that clothing would match a person of Mr. Martin's stature.
And those are all really great arguments to the jury, but as you know, we look at what has happened through a different lens, and so, to the extent that the jury saw the evidence and heard the cross-examination and concluded that your client was guilty, we need to assess whether the record could support that. So the record is that your client associated himself with that bedroom, that a piece of mail with his name and the address of that apartment on it was found in that bedroom, that the drugs were found as you've described, drugs and money. So why was that not an adequate evidentiary basis for the jury's conclusion?
Well, basically what we're looking at, again, under a Lattimore standard, Lattimore looks at, could a reasonable jury have come to that conclusion? Our argument is, based on the evidence, we don't believe they could have, because of the simple fact that that other evidence that could have been introduced, and during cross-examination, all of the 5 police officers testified that, yes, he shared a bedroom. Yes, it could have been someone else's. Who did they ask who the drugs belonged to? No. Did they ask where the money came from? All 5 police officers testified no. So that was part of the record.
Under Lattimore, we have to discount anything that doesn't favor the verdict. All of that does not favor the verdict, so it doesn't enter our calculus.
Okay, then from that point of view, we can then move on insofar as, assuming he did possess the drugs, okay, was it for the intent of distribution? And looking at it through that lens, all of the officers again testified there were no cutting agents, there were no glassine bags, there were no digital scales.
But there were 10 bags of crack individually packaged within another larger bag in close proximity to $3,000 in cash rolled up in bundles, to which the detective testified was more consistent with distribution than personal use.
Basically because, and I believe the officers testified to this too, the way they were packaged, there was no protocol insofar as whether someone is a seller or a buyer. If they are a heavy user, they could have just bought them the same way.
He had $3,000 in cash, and the crack was worth between $400 and $500.
Well, the cash, with all due respect, could have come from anywhere. It could have been a loan.
Remember Lattimore standard again.
I'm sorry?
You have to remember the Lattimore standard.
Looking at the Lattimore standard, I understand. But again, it's also a reasonable, and I understand with Lattimore, could a reasonable juror have come to that conclusion? I understand. But I think, Your Honor, if you look at the totality of everything, even the weight of the drugs, okay, under the Acosta case, 3.16 grams of cocaine was insufficient. Here we're talking a little over 4 grams, and that included the packaging. When you subtract out the packaging, the amount that was found would have almost come below the Acosta. And this court said in Acosta, 3.16 grams is insufficient for distribution. So I think when you take the totality of everything, the weight of the drugs, the fact that there were no cutting agents, there were no digital scales, there were no glassine bags, I think looking at it from that point of view is very, very important. Also, the Commonwealth argued that in order to determine whether something is for distribution or for personal use, you need an expert witness, okay? In deference to the Commonwealth, they tried to get in an expert witness. They filed a motion to bring in an expert, and the trial judge denied the motion. And according to Rodriguez case, which they state, and the Grinnet case, you need an expert witness to be able to inform a jury what's the difference between distribution and personal use. So I think just on that alone, Your Honor, we're looking at something that's very important. This was not a lot of drugs.
As I said before, there was testimony that this was packaged in a way in connection with the money that made it more consistent with distribution than personal use. And the jury was free to credit that, weren't they?
Of course. That's why.
So then we wouldn't need an expert.
Well, again, according to the case law, an expert is usually called in on these cases. And the Commonwealth conceded that. They fought very hardly, and it's in the transcripts, to get an expert. They even said, if we don't get an expert, these are going to be potential grounds for appeal. And that's one of the reasons why we're here, too. So I think if we look at the totality of everything, Your Honor, we're basically looking at, even if you did possess.
What case from this court or the SJC says that we need an expert opinion to prove intent to distribute?
Again, looking at the Acosta case, Your Honor.
Acosta. Is
that
in your brief?
Case. I'm sorry?
Is that in your brief?
Yes, it is.
Go right ahead.
Thank you. When the officer asked, when the defense attorney, asked one of the officers, well, since the drugs were all in a room where both parties had equal access to it, why did you arrest Mr. Martin? And his answer was, it was protocol. Well, again, the drugs were found in a drawer with men's clothing, okay? And again, getting back to Lattimore, I totally understand that. But again, we're looking at the sufficiency of evidence that was before the court and whether or not the judge should have allowed a required finding of not guilty. I mean, to come up with an answer that we arrested him only because it was protocol, well, what would have the protocol been if the drugs were found in a drawer with ladies' garments or in a drawer with mixed garments? So basically, he connected the drugs because they were in a drawer with men's clothing. Which man, we don't know. Yep, thank you, Your Honor. Insofar as, and again, we're looking at the second issue, which basically would be the confidential informant. And I'm looking at the Brzezinski case in that case there. And in the Brzezinski case, what they're talking about is a difference between a tipster and a police agent. In this particular case, and according to Brzezinski, the SJC held that the Commonwealth's interest in maintaining confidentiality of an informant who acted as a tipster leading to the issuance of a warrant was shown to outweigh the defendant's interest in disclosure. But also they said that if it's a mere tipster versus a police agent, then there's a level whereby the confidential informant's identity could be revealed. And basically what they stated was, I'm sorry, not they stated, the Diaz case says if there's a question between if a confidential informant is a tipster versus an agent of the police, there should be an in-camera hearing. The motion judge basically just noted on her denial that she did the balance test between, I believe, Rivario and Brzezinski and came up with the conclusion that the confidential informant was a tipster. Okay,
so was Mr. Martin charged with anything that was obtained through the controlled buys that the confidential informant performed?
Was he
charged?
Yes, he was charged. He was
was he charged with the drugs that were obtained in the controlled buy?
Yes. Yes, the integral buy included cocaine, and he was charged with possession with intent to distribute cocaine.
He was charged for the cocaine that was found in the bedroom.
That's correct.
And the confidential informant was not a recipient witness to the drugs found in the bedroom.
I understand. The law is clear.
So under Brzezinski, he's a tipster. And you don't.
Yes.
He can't. Well, how you don't say in your brief how the disclosure of his identity would have assisted in the fairness of the defendant's trial. Well, can you tell us how here?
That's the issue. We don't know how because of the fact
so
if
you can't say how he would have helped.
Not unless we know who he was.
He wasn't there in the bedroom, right?
He was not there in the bedroom, so therefore he's not a recipient witness. And I understand confidential informants can be revealed if they are a recipient witness. But also, according to Brzezinski, how do we determine if he was a tipster? If we read the very, very first part, the first sentence of the affidavit, all we know is, within the past 5 days, I, the detective, had an occasion to speak with a confidential informant who wished to provide information. So we don't know if the police officer approached the confidential informant and asked him to do work, or did the confidential informant come forward and say, I have a tip?
In Brzezinski, they say just providing information that helped with the issuance of a search warrant does not entitle you to the identity of the informant.
Well, in this particular case, if he was being recruited by the police, then he would become an agent of the police. If he was a tipster, no. As a tipster, he absolutely would not have his identification revealed. Totally understand that. But the way the affidavit is written and the way the judge reached her decision, we don't know. All we know is she's basically in 5 or 6 words said, I did the balance test between Ravario and Brzezinski and determined he was a tipster. And therefore, if he's a tipster, you don't identify him. She never mentioned anything about a police agent. She, unquote, just called him a tipster. We don't know if he was a tipster because based on the affidavit, we don't know if the police approached
Wouldn't every
the CI.
confidential informant be an agent of the police?
Could a confidential informant every
Wouldn't
time?
every confidential informant be an agent of the police?
Potentially, depending on how.
I mean, they don't freelance.
No, exactly. No. However, if it depends on how I think the association comes together. If the police are working with a confidential informant already on a particular case, then perhaps not. But if it's a tipster who just comes forward.
I think we understand. We're going to have to leave it there. Mr. Nadeau.
Any other questions? I'd be happy to entertain.
No, your time is up. Thank you.
Thank you.
Good morning. May it please the court, Stephen Nadeau on behalf of the Commonwealth. Excuse me. To begin with the sufficiency argument, I agree with Justice Hirschfang's point or question made earlier that the defense argument is essentially good grist for the jury, but under the Lattimore standard, I think clearly over the bar here to show both that the defendant had at the very least joint constructive possession of the contraband found in the bedroom as well as the intent to distribute it. This is not a case where he was just merely present in the apartment or even just merely present coming out of the bedroom where everything was found. He told the officer that that's where he stays with his girlfriend. There was a letter from a mailing from Commerce Insurance with his name and the address of the target apartment on it. In the closet, pretty much any of the sort of active evidence in this case was found among men's effects. Men's clothing is where the drugs were found. And then underwear drawers where the first bundle of cash was found, and then the men's shaving kit, 3 additional bundles of substantial amounts of cash, about $1,000 per bundle. So all that taken together, I think, suffices to establish, again, at the very least, joint constructive possession of the drugs. The intent here would be based on the nature of the bundling, one bag containing multiple smaller baggies, and then the amount of cash found in close proximity, again, all seeming to belong to the same person. And with the, again, as my brother pointed out, the trial judge did not permit a separate expert to come in and testify, preferring to have the percipient officers testify to those same sort of facts, which, as I understand it, is in tension with the best approach, but that's nonetheless how the evidence came in here, and those officers did testify that again, the manner of packaging, notwithstanding a arguably small amount, and the cash tips the scale.
What do you mean when you say tension with the best approach? You think the judge should have allowed the expert in?
I'm sorry?
What do you mean when you say in tension with the best approach?
I'm just speaking of the case law that generally the percipient police officer witnesses should not generally be allowed to opine onto features of the drug trade because it sort of creates a bootstrapping effect.
Best practice having a separate witness.
Yes.
Okay,
Yeah.
Okay, thank you.
Although by the same token, without necessarily offering an opinion, I know investigating officers can testify to the investigative significance of things they find. Why did they seize particular things as they're executing these search warrants?
Things they found and seized. I was a little mystified by the decision to charge the defendant with possession of ibuprofen and antibiotics. I know you didn't make that decision yourself, but can you shed any light on it?
Yeah, I don't really know. I don't. Again, with the ibuprofen, I don't know if it was an amount or dosage that is the concern there. I think there just sounded strange to me as well. I don't know if the officers just kind of took what they had and will issue a charge based on all of it, but certainly not.
It's weird.
Yes, yeah.
I want to protect against liver damage.
Yeah. And for that reason, don't rely too heavily on that evidence as far as everything else. But I think the balance of it certainly suffices. Turning briefly then to the informant question, as mentioned here, the only alleged involvement by either side of the informant is that he was the initial tipster and he participated in at least one controlled buy, but there's no indication that he has any evidence to offer as to the execution of the search warrant that gave rise to the charges here. And I think Gandia and Fernandez both cited in the Commonwealth's brief kind of state very directly that typically the CI, even when participating in a controlled purchase that leads to the search warrant, is not subject to disclosure based on evidence found during the execution of the warrant. So I think the judge well within her discretion in denying the motion on those grounds. If there are no questions, that is essentially all I have.
Seeing none, thank you. Thank you both. We'll take it under advisement. Our next case is 23P 1141 Commonwealth versus Williams. Ms. Raynaud.
Sorry. May it please the court. Suzanne Renaud for Irvin Williams. Your Honor, this is here on a probation revocation issue, and the issue really boils down, especially, I'm sorry, I don't think my time has started. Okay. Again, Suzanne Renaud for Irvin Williams. The issue here really boils down on, at least on the criminal matter, about substantial reliability, because this is a case where we have documentary evidence. It is the affidavit, and as Costa has told us, there doesn't have to be deference to the findings of the judge when you're dealing with a revocation based on documentary evidence. But even if you were to defer, there are clear fact-finding and legal errors that kind of imbued the determination of substantial reliability. And hard field factors, patent factors are very well settled, but what they are a totality test, which means that not every factor has to be met, but some of them are more important than others. And this is sort of an unusual situation because we don't only have a recantation, we have somebody who's been found credibly to have lied under oath to the point where the Commonwealth was going to bring perjury charges against her. And the judge completely discredited everything she had to say because she had these demonstrable lies that were about the issues here. So this is really a case where we cannot have any presumption that when she's swearing something under oath in an affidavit, that she's being truthful. I think that the corroboration or anything independent of what she personally has to say probably takes outsized importance in this particular totality test. And so there were in her affidavit basically two things that she said were potentially corroborative. And then when she spoke to the officer, there was a third thing. She said, oh, he keeps text messaging me, but she never showed those to the officer. But the two things here are obviously the toe slip, which I'd like to talk about in a moment, but I'd like to start with the idea of the text messages. The domestic violence has to stop from the landlord. And the judge below really discounted that as having any significance, and instead actually seemed to say that those were probably sent. I mean, he didn't come out and say it quite that forcefully, but that was the implication. The problem with that is that there is absolutely no reason on this record to think that those were ever sent, because there were 2 discussions with the landlord between him and the state trooper who testified. And the judge here basically credited the trooper and credited what the landlord had to say in most respects, except for that respect. He talks to the trooper. He doesn't really want to participate, but he is yet still talking to her on the phone and says there are no text messages of those sort. A week or so later, we don't know where he lives, but we can assume, I suppose, that he doesn't live in the same building, so that makes the idea of him hearing this alleged domestic violence less probable. But she goes and she talks to him, and not only talks to him, she looks at his phone, and she sees text messages dating back at least to October.
You say she, you're talking about the
The trooper, yes. I'm sorry, Your Honor. Okay. So when the trooper actually sees this, so he is at that point cooperating with her, telling her that what the complainant has to say is not true, showing her proof that what she has to say is not true. The trooper was in a position to get those text messages at that point, and they just simply didn't exist. So to in any way say that this landlord, who didn't really want to be part of any of this, sure, he didn't want to be part of this, but then he was. But then to circularly say, but because he didn't show those text messages, they must have existed, when he in fact denied that they existed. That is actually a long way around of saying that this is just not reliable. And as a result, that one piece, really, truly independent piece that might have actually corroborated the assaultive allegations, and incidentally, the 2 assaultive allegations are the only ones he was found in violation on, that simply doesn't exist. And so that's, one of the main starting points here. In addition, the other major legal error that the judge below made was saying that this all happened close in time. 2 weeks is not close in time. Costa says 2 weeks is not close in time. Other cases, if you look at what it means to be close in time, and there were a number of them that were cited in the memorandum, the motion for reconsideration that I filed, close in time usually means a day. The same day, maybe the day after, mainly so that the police can get corroborative evidence, so that they can, it's not the same as a spontaneous utterance, but there's more likeliness, a higher likelihood of there being truth, that somebody doesn't have time to sit and deliberate, to use the court system as a weapon, which is what this complainant said she was doing, and even some of her text messages indicated that is in fact what she was doing. So 2 weeks is not close in time. And it's not like the case in Costa where there was an exception that was made where they were live-in partners, and because of that, it was harder for the complainant in Costa to get away to the point where she could tell the police that she was having an ongoing series of sexual abuse. These are not live-in partners. In fact, all the evidence that is suggested, including in the affidavit, is they never even see each other. They certainly don't live with each other. The issue that she was having was, so she said, was that she kept getting text messages from my client. So those 2 pieces don't corroborate this. But I do want to talk about this toe slip, because I know that is...
I'm sorry, and if I missed this, but
sure.
You said there was nothing that corroborated the phone calls between the 2?
The phone calls between August 13th and September 1st. The phone calls, I should say that there is Exhibit 3, which I didn't submit to the court, and perhaps I should have.
Excuse me, what about between September 2021 and January of 2022?
Well,
that's Exhibit 3 that shows hundreds of phone calls.
Yes, so, Your Honor, I want to just...
So I'm missing when you said there was no corroboration.
So in her affidavit that was signed on September 3rd, she said, I have a series of text messages. When she spoke to the police officer on September 1st, she said, Mr. Williams won't stop text messaging me. Those are the ones that I'm talking about that she never submitted to the police officer. She didn't show him those. There is certainly...
The ones that were, the T-Mobile records showed hundreds of calls back and forth.
But those started, now, the one thing I don't know is, off the top of my head, is when T-Mobile was asked to start producing those. But the ones that we have, and I should have submitted this to the court, starts on September 20th. And if you look that very first week of phone calls between them, it's all incoming. I know, granted, the phone gets answered. All incoming. It's 5 a day, 7 a day, 6 a day. 9 a day on that very first week, starting on September 20th, all coming from the complainant to Mr. Williams and not in the other direction. So what we don't have here at all is anything corroborating that her claim, he will not stop texting me. And that was what she was saying in the affidavit. We have absolutely nothing to corroborate that, even though she had the chance to show that to the police officer, but she didn't. So in that sense, Your Honor, you're correct. There are phone calls going back and forth between these two who had a relationship such as it was.
During the period of the no contact order.
Well, Your Honor, obviously I take issue about whether or not that no contact order was in effect, but that is true. But they weren't being complained about in a criminal sense or in a 209A harassment sense from September 20th on. Clearly, those were ones that were being invited by the complainant because she was initiating the calls at that point. What she was saying in her affidavit was that his phone calling was causing her, I suppose, fear because he wouldn't stop calling her. And that is absolutely not substantiated. So I wanted to separate those two time periods. If you would. And, what she's basically saying when she comes to court on September 17th is that I wanted to keep having a relationship. He didn't want any part of me. That's why I did this, because I knew he was on probation, and basically I wanted to go and get him, which is consistent with the fact that she starts calling him incessantly, basically, starting on September 20th, not the other way around where he is calling her incessantly and putting her in fear. And that's the point on that issue. On the toe slip, because I realize that sets the stage here for that the two of them saw each other on August 13th. That clearly happened. The two of them saw each other on September 13th. But what it doesn't do is tell you any more than that. It doesn't tell you about the alleged assault. It doesn't tell you about whether they had any fight, physical or verbal, that day. It just tells you that they saw each other. I want to point the court to Commonwealth versus Ortiz, where there was a complaint that was made of malicious destruction of a car, and the court said, the police officer saw damage on the hood of the car. But even though that was consistent with the allegations that were being raised by the complainant in Ortiz, because there was no other way to make a connection between the criminal act and that damage that they saw, they said, we're going to discount that as corroborating the alleged crimes. And that's what I think kind of has a parallel here. Yeah, there was a toe happening, and maybe it even caused the damage to the door frame, which wasn't enough in, say, Commonwealth versus King, but you could say it did. We do know from what the landlord said that the door still worked, which is a little bit against what she said in her affidavit, where she said the door doesn't lock. The landlord said in October the door still worked. But putting that all to the side, it's not telling us about whether those allegations that when she was in the shower, before or after she was in the shower and he hit me and threw me on the bed, it's not telling you anything about that. I want to contrast that as well with Commonwealth versus Negron, where the person said, he torched my apartment, and it was the same day. The police go in, and there's some kind of ephemeral smoke that would not have been there otherwise. If in Negron they'd come in and said, we see some damage to a stove, but we don't know what date it happened, that wouldn't have been corroborative. What happened in Negron, though, is that the smoke was still actively billowing. That's very different than the damage to the car in Ortiz, which is also, in the Ortiz situation, is similar to this. It's not corroborating. In some other case, with some other witness who has more reason to believe that she might not be lying under oath, that level of corroboration might be enough.
Did you want to say anything about the no contact issue you raised?
I'm sorry, to talk about the no contact issue?
You're running out of time.
Thank you, Your Honor. The no contact issue is that we have a very clear difference between the written order, which I admit says no contact.
Your client signed that.
And the client signed that.
After that weekend.
That is correct. To be fair, we're talking about the order, the probation violation hearing notice said the September 17th order. So the question is, what was the judge's September 17th order? And if the judge's order could be interpreted in two ways, very clearly, the written part of her order said one thing, but the oral part of her order said something else, and that is the problem.
The judge said, do not text Ms. Chavez, do not call her, nothing.
You're absolutely right, Your Honor.
And
But
the judge places no limitation on that. She does not say this weekend.
Your Honor, I disagree with that, because I think if you read...
I'm sorry, where in the transcript did she limit it to this weekend?
So, Your Honor, on that section, she was talking first about how she wanted to make this the least restrictive thing possible, and then she turned and she said, but we don't have GPS on this day, and I'm sorry, I'm trying to find the page citation, but it's right after that. She says, we don't have this, so what I want you to do is, I don't want you, certainly my order is not to go anywhere near Ms. Chavez.
Can you give me a page number?
Yes, sorry. Oh, boy, page 47 into page 48. She says, my order is GPS, but basically she said, but unfortunately we don't have that. And then she says, certainly my order is not to go anywhere near the complainant. Now, she wouldn't have had to say that if GPS was part of this conversation. She said, but her next sentence on page 48, do not text her, do not call her, nothing. If she shows up at your house, do nothing with her. She's contextualizing that absolutely, completely within that limited time frame. And then as the discussion goes on, she continues to talk about not contacting the complainant during that limited time frame.
I'm not seeing the limitation that you're telling us about.
Your Honor, this is how...
So she didn't expressly limit it to the weekend, which I believe you told me a minute ago.
Did she use the words, this is only the weekend? No, Your Honor. No, she did not do that. Right. I'm sorry. But I think that as this discussion is unfolding...
Well, you have an argument that she limited it to the weekend as opposed to her actually limiting it to the weekend.
Your Honor, I would say that she did not explicitly said that. I think that her context of her...
Why would that make sense? You know, I hate to bring in common sense, but here it is. Why would the judge limit it to the weekend, and when the weekend's over, she has a written order that limits it in no way whatsoever?
That's a very good question, Your Honor. I just want to point out that when the clerk read it into the record, it did also say, in the meantime. But the reason why, Your Honor, is how she expressed on page 47. She was trying to make this as limited as possible. Her concern was mainly the allegations of abuse. She was trying to make sure the two of them weren't coming into contact with each other. There was all this testimony before her that they wanted to maintain a relationship with each other, a relationship that was mainly over text. I think it makes sense to say that not speaking to each other actually doesn't advance the goals of protecting the public.
I'm going to leave it there. Thank you.
Okay. Thank you, Your Honor.
Ms. Gauthier.
Good morning, Your Honors. Excuse me, Stacey Gauthier for the Commonwealth. It's our position that the revocation of the defendant's probation should be affirmed. With regard to the no contact order, the judge properly revoked the defendant's probation for violating the no contact order. Excuse me. Oh, 1 second, sorry. Judge Sullivan never, either in writing or orally, limited the no contact order to just the weekend. She wrote specifically in her, the written probation of condition order, just no contact with the victim at the victim's address. There's nothing on there that says it's only limited to the weekend or until he gets the GPS off.
So is your argument that any ambiguity that arose at the Friday hearing was...
I'm sorry.
I'm sorry. Is your argument that any ambiguity that arose during the Friday hearing was resolved in the written Monday order?
I would suggest that there was no ambiguity.
Okay, but let's assume there was ambiguity.
Okay, so if
is
there
that your
was...
position that it gets resolved in the Monday written order
Yes.
that the defendant signed and that resolves the issue?
Yes, the defendant signed it. The judge signed it on the day of the hearing, at a time when I would suggest would be fresh in her mind the conditions that she set. So if there, of course, I'm saying there was no ambiguity, but if there was, it would have been resolved in that signed order of probation conditions that the defendant then signed. But then, and certainly the court can interpret a transcript just as well as I can. But if you just look at, on page 47, when the judge starts with her order, she says...
I'm sorry, can you tell me the date of that hearing? I'm trying to find page 40.
September 17th.
All right,
Thank you. Thank you, Your Honor. On page 47, second paragraph, she starts saying, but this domestic violence is sort of a cyclical crime where victims very frequently recant and then further problems. So my thought is this. I think pending the resolution of this alleged probation violation, that GPS monitoring makes sense with no... And then she kind of cuts herself off and starts talking about, no curfew or the fact that, no one is there to put the GPS on. But she starts saying no, something. And then she gets back on track after they talk about there's no one there to put the GPS on. And at the very end of the page 47, she says, certainly my order is that he not go anywhere near Ms. Victim, not her home, don't text her, don't call her, nothing. If she shows up at your house, have nothing to do with her. So she starts saying no, something, and then she kind of cuts herself off. So I would suggest...
It's not very clear.
I mean, I would
What do you
suggest
make
that
of
she was
the
saying...
fact that the clerk follows up and says, you got to show up Monday to get your GPS put on? In the meantime, you're to have no contact, absolutely no contact with either directly or indirectly with the complainant, right? So that seems to suggest, in the meantime, that there is a duration that's limited to the installation of the GPS device.
Well, we looked at not what somebody else says, we look at what the judge says, and that's the McDonald case where a probation officer had written in a condition that the judge didn't order. So
Sure.
if
The clerk could not contradict what the judge said, but here you're kind of depending on ellipsis to sort of support your case, which doesn't seem very strong.
Well, I've also got the written order. I mean, certainly the stronger argument is the written order that she signed on, on the date of the hearing. I mean, certainly we know that from her order that if she only wanted to limit it to the weekend while the GPS was on, she had done that with regard to the GPS, or I'm sorry, to staying with his uncle, right? She said, reside with, uncle until GPS put on. So if she only wanted the no contact order, she could have put that, just, no contact just through the weekend.
Can I ask you to shift gears for a moment, or permanently, that's up to us, I guess, and you, to talking about the substantial reliability question. Can you point us to a case in which there was a delay, anything like the 2.5 or so weeks here between the event and the affidavit?
So last night, in preparing for argument, I re-looked at the Costa case, the SJC case, which is cited in both of our briefs. And on pages, it went from 124 to 125. My understanding of that case, although I didn't bring it with me, so I can't double check, but my understanding of that case was that was a domestic case, boyfriend, girlfriend. The victim had reported a series of rapes that occurred between October of 2018 and January of 2019. She reported those incidents in February of 2019 and March of 2019. So she reported them approximately 1 to 2 months later after they occurred. And what I reviewed last night in Costa, the SJC in that case found that was in fact close in time. And that's on pages 124 and 125. I can double check when I get back to my office. So that's what I would support. That's certainly longer than the 2 to 3 weeks that the reporting have occurred in this case.
I think you're right about that, at least in my view. The factor in Costa that, as your sister pointed out earlier, is not present here is that there was an overlay in that case of an abusive domestic situation between the two of them. Do you think that's a distinction without a difference?
Well, I mean, there certainly seemed to be, according to the victim in her affidavit, there was a history of domestic abuse here. She had put in her affidavit that the defendant had been, now I forget what her exact words were. She said that he had been, I think, belittling her and, abusing her. I don't recall her exact words, but I believe she had put that in the affidavit. And then she kept telling the officer also that she had low self-esteem. So I would suggest it's the same.
Which is, I think that is also a way in which people can be abused and are abused. I guess the distinction I would draw is that there was nothing physically stopping the victim in this case from reaching out. And by her own affidavit and her testimony later, they were not in a domestic relationship. He didn't live there. They weren't spending time together. So I am not at all belittling the intense psychological and emotional effects and the suppressive effects of, on one's ability to represent oneself effectively of being in an abusive relationship. But at least in terms of her actual ability to reach out, it was not the same as Costa.
No, that's correct, Your Honor. That was different. I would point out that, Hartfield doesn't say close in time. It says close in time. It doesn't say at the first available opportunity. So that's what I would say to that. And certainly, again, Costa, she wasn't allowed to leave, but again, that's 2 months. Here, it's like 3 weeks. I would just suggest that it's very similar with the domestic violence as to Costa, although yes, I agree, she wasn't, told she couldn't leave. But there's no limitation. It's got to be at the first opportunity. And then the other thing that I would just say is, certainly the court can look at an affidavit just as well as the motion judge. However, here we had more than just documentary evidence. The victim testified, and the judge went through her. Now, not only did he look at things that were corroborated from the affidavit and the report she made to the police, he also looked at inconsistencies in her trial or her hearing testimony, and he found that her testimony was inconsistent in that she had told or she had testified that the defendant didn't even drive a car during the incident, and we have the tow receipt from the defendant, a car registered to the defendant being towed outside her house on the day that the incident occurred on August 13th. She also stated that, the fire department had broken the door and that's why the door was broken. But then the landlord testified that, yes, the fire department did break the door in 2019 and he fixed it. And now it had been broken again, within the time period surrounding the incident in the probation hearing. She also said she didn't have the defendant's phone number, but it appears from text messages and from the landlord that she was communicating with him by phone. So, the judge also looked at that too, and it's certainly within his discretion, the weight and credibility of the testimony, as he was the one who saw all the witnesses testify.
So I guess that's something I struggle with when I think about this case, and I apologize in advance because I haven't been able to articulate it very well for myself, so I won't do very well now. But you have a judge who's faced with a witness who is determined to be a liar. And so then that leads to the question, well, was she lying then? Is she lying now? Or is she always lying? And the judge has made a determination in this case that she's lying now and she wasn't lying then. To what extent, if at all, does that credibility determination, is that credibility determination something that we should or should not or can or cannot review?
Well, if it was just documentary evidence, then obviously this court can review de novo. Right. Because you're in the same position, but it is different here because the judge actually saw her testify. So I think that her testimony and the judge's finding of her credibility or lack of credibility, I think that this court needs to defer to the judge on that because there was also testimony.
Do you have a case that is similar factually where, because the cases, most of the cases, right, like Hartfield, there's just an affidavit. But here we have an affidavit and then the affiant. Did you find anything like that?
I don't. I'm happy to go back and do some more searching and I can,
We can do that.
Okay.
Is there anything else you'd like to share with us?
No, if there's no further questions, I'll rest in my brief.
Seeing none, thank you.
Thank you.
Thank you both. next case is 23P1231, Commonwealth versus Tinkham. Mr. Corman, welcome back.
Thank you, Your Honor. Good morning, Your Honors. May it please the Court. My name is William Corman, and I represent Mr. Tinkham in this particular matter. I'd like to address the second issue in my brief first. I find myself once again expressing concerns to this honorable court about the closing arguments and the propriety of closing arguments that seem to be coming from the district attorney's offices, especially in cases like this. We have a case in this particular instance where it's a delayed disclosure, there's absolutely no forensic evidence, and the entire case boils down to the credibility of the alleged victim and whatever other witnesses there are. And nevertheless, despite these very, very narrow rules that have been set forth by this court, by the SJC, over and over and over again, we have prosecutors who I would respectfully suggest stray far from the bounds of appropriate closing argument. This case is, oh my gosh, here we go again, where we have a prosecutor who I would respectfully suggest is introducing facts not in evidence to the jury.
Well, she explains that she's drawing an inference based on the evidence, which she can do.
Sure. There's no problem with that in a vacuum, but it has supposed to be an appropriate inference. And I would suggest that in this case, what the prosecutor is actually doing is she's adding an element, not a criminal element, mind you, but she's inserting a fact that would be crucial in determining why things did or didn't happen. So she's drawing an inference that I suggest really doesn't have a basis. The judge essentially agrees.
Well, he did babysit or was the caretaker for the previous 4 summers.
Yes.
And then we're heading into summer again, and her sister sees her crying, and then she makes the disclosure, and the inference being that she doesn't want to be subjected to the defendant this coming summer.
That's correct.
Why isn't that reasonable?
Because I suppose my answer is this. The prosecutor has an obligation to present to a jury facts that are in evidence and not to surmise why things happen. I would suggest that, yes, prosecutors can certainly create inferences and so on and so forth, but in this particular case, it's a bridge too far. In this particular case, the prosecutor is now taking on the role of why a disclosure is happening at a particular time. And it's not just why a disclosure is happening at a particular time. Then I would suggest that by using those statements and by discussing it, she's asking the jury to sort of reach down into the pit of their stomach and be like, oh my God, that's why this disclosure happened now, because God forbid it happens again.
The fact that he took care of her for the 4 prior summers, that's in evidence.
Yes.
And the fact that summer was coming soon, also in evidence.
Yes.
And prosecutors are entitled to marshal the evidence in a fair manner and to permit the jury to draw reasonable inferences that only have to be possible. It's a very low standard.
I mean, the phrase Your Honor just used was in a fair manner. And this isn't a fair manner. In other words, in this particular case, the prosecutor is inviting the jury to hypothesize as to what would have happened had this disclosure not happened on this particular date. And in doing so, by inviting them to hypothesize a fact that we know nothing about, I mean, the calendar pages are the calendar pages, but by inviting them to hypothesize essentially what would have happened if the disclosure didn't occur at this particular date, I think we can assume, ladies and gentlemen, that it would have kept going, would have happened again. That's improperly inflaming the passion of the jury. It's almost like, it would almost be as if the prosecutor said, ladies and gentlemen of the jury, thank God this disclosure happened when it did, because otherwise we would have had another set of sexual assaults.
Well, she didn't say that.
Well, but I know that's not what she said, but I would suggest to the court that that's the inference that they're looking to draw. But for this disclosure at this exact moment, it would have happened to this kid again. And that's where the impropriety lies, Your Honor. Again, a fair inference or by means that are fair is one thing. But here we're basically dragging the jury along through the calendar pages and saying, thank God the disclosure happened when it did.
Was this a factual question? Was it in play a challenge to her delay in disclosure? Why did she wait so long to disclose this?
So
Was that a claim that was being made by the defendant?
it was a claim that was being made by the defendant, but not so much to the victim as to the mother, because the mother is the one who then, for lack of a better phrase, sits on it. And she testifies as to why she did. She was confused. She wasn't sure what was going on. She had to process it. So I think that the defense really focused on the overall delay in disclosure, in no small part of it being the mom's. I apologize.
There was some discussion of the delay of,
Yes.
of the victim delaying. So that was an issue, right?
Yes,
Judge, I
and
think
moms as well.
The Commonwealth's argument may be like, well, it was reasonable to infer that NP didn't make the allegation sooner because it wasn't until March 2021 that she realized her mom would be returning to work in April, and therefore, the defendant would be babysitting, right? So that kind of explains the timing with respect to NP, right? So isn't that an issue that's in play and a fair inference to be drawn from the timing of NP's disclosure?
So my answer is yes, but, which is a fantastic answer. Sort of like it depends. I think the answer is yes, but what ends up happening again is, to use the phrase I used a moment ago, it's a bridge too far. I mean, again, the prosecutor, had the prosecutor not said that, I think that the argument is fine. But to basically say, and again, I am paraphrasing, sort of, jurors, you have an obligation, we are lucky that we are here today and not a year from now if it happened again. And I think that's where the impropriety lies. And the problem we have, again, since it's a delayed disclosure, there's no forensics, there's no, we just have the credibility here. And I would suggest that when we have cases that just rely upon the credibility of the witnesses, those are the cases within which the Commonwealth has to be the most cautious in their closing arguments. And unfortunately, those are the cases where I think they continue to step over the line. And the judge here agreed. The judge here essentially says there's no evidence to support that theory. There's no evidence whatsoever about that.
Arguably, there wasn't evidence.
I'm sorry. Well, no, what the judge says, there is no evidence to support the argument, is what I should say. And defense counsel basically says, what are we going to do about it? And the judge is like, my normal instructions are fine. I don't think that's appropriate. I mean, again.
Did he ask for more?
I think that it's implied that when there is an objection to a closing argument, which I think everyone in this room can recognize happens far too infrequently. I mean, often we're sitting here.
You don't need that. They did ask for more. On the transcript of the charge on page 93.
He asked for a curative instruction.
Defense counsel says, I would ask the court to tell the jury that you've heard argument and that the specific time when the victim made this disclosure, and that was a misstatement of the facts.
I'm glad you're here, Your Honor.
But what I meant was, after the charge was given, did the defendant then say, I'm sorry, Your Honor, that's insufficient? No.
He asked for something, it wasn't given, or the judge essentially said, it'll be covered in my normal instructions. And I would respectfully suggest that, again, in these cases where we're dealing with credibility and credibility alone, those are the cases within which the Commonwealth needs to be the most cautious, and unfortunately, in this case, they were not. And if there are no further questions, I'll rest on my brief.
You don't want to go into the first one?
I think we have it.
Okay.
Thank you, Your
Mr.
Honor.
Foreman. Thank you. Mr. Townsend, welcome back to you as well.
Thank you, Your Honor. May it please the Court, Thomas Townsend with Commonwealth. I want to clarify the record in a couple of aspects. Most recently, the excerpt that Your Honor just read. What happened here was, after the prosecutor's closing argument, defense counsel objected. The objection was not to what we've been discussing here. The objection was that there was no evidence as to when she disclosed, meaning March or April of that year. And the judge said, quickly brushed that aside and said, but what concerns me is what evidence do you have, having to do with the issue right here. Counsel was a little bit slow to pick up on the judge's complaint, and that excerpt where counsel asked for the curative instruction, that had to do with, to quote it again, I would ask the court to tell the jury that you've heard argument that the specific time when the victim made this disclosure and that it was a misstatement of the facts. She was still on her initial objection. Shortly after that, defense counsel caught on and said, oh yes, I agree with your honor about the issue we're discussing here. So there was not a request with respect to this.
Not initially, but.
Not initially, but she didn't after the fact go, and I would like a curative
right.
instruction to address your honor's concern. She was looking for a curative instruction to her initial concern.
Yeah.
And the very fact that she didn't object to the argument with that having to do with the inference shows that the tone, tenor, and content of the prosecutor's argument didn't seize her at the time, although it did, the judge thought of it. And eventually, defense counsel did object. So I agree there's a prejudicial, a prejudicial standard applies here, where otherwise I'd be arguing it wouldn't, because she did adopt the judge's concern. The other point I want to make is the delay by the victim was a big part of the defendant's case. I would point specifically to the closing argument, volume 5, pages 68 to 70. Defense counsel says, I want to talk a little bit about delay, and then makes an argument criticizing the victim for not delaying, or for delaying and not disclosing earlier. And at a couple points, she says on page 68, the point is that she had opportunities to tell and she didn't. And then defense counsel didn't leave it there, but made more arguments about the delay and repeated. The point here is, and this is on the next page, page 69, the point here is that if these things happened, the victim had opportunity to tell and she didn't at the time. And that is just another factor for you to consider when you assess her credibility in this case. And she didn't leave it there either. She argued for almost another page about the delay. So that was the context where the prosecutor got up. And this was just one argument in a lengthy 16-page closing argument. And that is where the prosecutor said, well, the reason, or you can infer, I don't think she used the word inference, but it was based on the prosecutor's inference of the evidence. And the evidence did support the inference that she had learned that the plan was to spend the summer again with the defendant, and the victim was crying for several nights. The older sister went in and drew it out of her. And so the prosecutor argued that is the reason she disclosed at that time. So it was largely responsive to what defense counsel had argued.
But there has to be a line where prosecutors cannot cross, particularly when it comes to attributing thoughts and motivations to a victim of crime, right? I mean, so I guess I want to get your sense of what you think that line is. I mean, it's one thing to say it's an inference from the evidence, but here it was more along the lines of she didn't report till X time because she was concerned about this, right? And so it's one thing to sort of say, well, you can infer, or maybe you can surmise from the facts, but it seemed more direct statement of this is what the victim was thinking.
Well, I think...
How do we deal with that?
I think there's a two-stage process. Number one, is there evidence to support the argument? And here there is evidence. And the prosecutor elicited from the victim. She did know that this was the plan for the summer, and she disclosed after that. And the prosecutor, and this is the second point, was the inference reasonable and fair? Now, it doesn't have to be inescapable. It doesn't have to be necessary. Was it reasonable and fair inference from the evidence that was there? And also I want to point out, and I argue obviously that it was, I think it's a natural inference. I also want to point out this was a short trial. Jury was sworn one day, 2 days later they returned with a verdict. There were only 5 witnesses. So the jury was there. They saw what the evidence was, and they received ample instruction from the judge who told them 4 times that the arguments of counsel are not evidence. And he also provided an instruction on what reasonable inferences the jury can draw from the evidence. And so I think a properly instructed jury is able to discern what is a proper and improper inference from the evidence, as I argue that this was a natural inference that the prosecutor drew. It wasn't, it was based on the evidence, and I think it was fair and reasonable inference. And unless there's any further inquiry from the court, I've made
Seeing
my
none,
points.
thank you. Thank you both.
All right, thank you very much.
We're going to take a short recess.
Court, all rise. Court is open, please be seated.
Our next case is 23P1265, Casher Krulich versus Pachotto. Ms. Pachotto.
No one should be shy about correcting our pronunciation, by the
Oh,
way.
that was excellent. Very good. That was good. Good morning. My name's Melita Pachotto. I'm here with my family, my mother, Judith Pachotto, and my sister, Athena Pachotto. We're here today because Attorney Casher committed fraud. And that's the only reason why you know my name and I'm appearing before you today. But for her fraud, we wouldn't have this hearing today. And the fraud that I'm referring to is in her allocation agreement, which was a contingency fee contract. It was both. So rather than putting...
This is the underlying issue in the case that's been litigated and affirmed on appeal, right?
The issue is whether or not the judgment is appropriate that she's seeking to execute on. And I just want to establish...
Well, no, it's whether the execution is appropriate, not the judgment.
It's both, because I moved the lower court on both. And he said that he wasn't willing to adjudicate that, but he was going to leave that for you, if the judgment was appropriate or not. And I said that he had the power to adjudicate it.
I'm sorry to interrupt.
Sorry.
Which we do periodically, as you saw before. Yeah. So that was sort of the basis of my first question was, we're not going to, and nor do we have the ability to review what's already been affirmed on appeal.
He said that you do have that ability,
Okay,
and the law says you do have that ability, and the only reason why we're here is because she committed fraud.
I'll just say it differently then. It would be very helpful to us to decide this case if you explain why this alias execution was invalid.
I think that it's important when you look, I will do the alias execution. We've got 15 minutes and I will devote myself to that.
Goes by quickly.
Okay. But I think that it's important to take a bird's eye view of this entire action and why we're here before you today. Because the only reason why we're here is because she committed fraud in the allocation agreement and her settlement agreement, in her fee agreement. She made the allocation agreement, settlement agreement, and the fee contract, her contingency fee contract, one single item, and she made Juan Nunez, one of the parties to the case, to the 83 action, a party to the settling party to the 1994 action, in order to defraud the attorney lien holders of their fees for the work that they did in the 83 action. And that's why she put the allocation agreement separately in a separate contingency fee contract rather than the settlement agreement itself, in order to avoid having the attorney see the fraud that she committed. And what she did is she allocated nearly $2 million to Juan Nunez in that agreement. And that started off this entire tortious litigation, because what happened is Travelers Insurance said, we cannot pay under that contract because you've committed fraud. They couldn't pay. Had the allocation been done correctly with the right parties for the right amounts in the contract itself, then you wouldn't know my name. This entire litigation wouldn't have you wouldn't know my sister's name, and all of the money that was attached in the 1994 action, which was a judgment of over $3.2 million, plus money for unfair and deceptive acts and practices of Travelers Insurance, would never have occurred. And what happened is that the court determined that what they would do is they would unbind Attorney Casher from her contingency fee contract because Travelers couldn't pay the money to the settling parties directly. The only reason why they couldn't pay the money directly to her is because they would be involved in fraud themselves, and they didn't want to have the legal exposure from the Travelers Insurance Company. I think that it is very inappropriate to allow an attorney to commit fraud in a contingency fee contract, use that as the basis, the fraud that she's committed herself, on behalf of herself, to bump up her legal fees, and on behalf of, and move a party and move him to settle in another case, to witness that fraud and see that fraud and use that fraud as the legal basis for unbinding her from her contingency fee contract by saying that the insurance company can't perform. Because where this hearing should be had is at the BBO, because attorneys should not be allowed to commit open fraud like this and then have the appeals court use it as the basis to seize all of the proceeds of the 1994 action to pay to the head of the regulatory agency for legal fees in another case. We're talking about millions of dollars. And not only that, but to do it by attaching interest on a settlement against that is statutorily barred from being accrued. We put money on deposit with the court register specifically to avoid having people pay out huge judgments like happened in our case, where you have a $9 million insurance company settlement that pays out 2 separate judgments, plus the liability of the insurance company for their unfair and deceptive acts and practices for not paying out decades before and hiding insurance instead, okay? They have this huge pile of money, and it goes into the court register, and it disappears, and instead what we have today is a $12.3 million debt for my family for legal fees on a case where the only reason why you know our names, you know my name, you know my sister's name, you know any of the parties to the 1994 action is because she committed fraud that was so bad that the insurance company couldn't pay out, okay? And to use the opportunity of her fraud to enrich court officers that are highly placed, like the head of your regulatory agency, and say, well, thank goodness we have this pool of money that we have on deposit with the court register, and we can just unbind ourselves all from the laws which prevent this kind of gross injustice occurring. That is what happened. And so here we have today two lower court judges, Judge Welsh and Judge Crippellini, who both reviewed the contingency fee contract. And what they said is that there is no condition precedent in her contingency fee contract whatsoever that requires her be paid directly as opposed to the court being paid. There's no precedent. There's no requirement of who gets paid. It doesn't say in there the clients need to be paid or attorney cashier needs to be paid. All it says is that Travelers needs to pay. Well, Travelers did pay. Travelers paid quite a lot. We didn't get it. What we got is a multi-million-dollar debt, and it goes back to her fraud. And to go and unbind her from the constraints of her own contingency fee contract based upon her own fraud and create a condition precedent that could not be met because of her fraud is wild. And that is why you have a judgment that's so outrageous, it's so facially, without even knowing the facts of the case, unhinged. It's unreal to settle a case for $9 million and be showing up to court to have your house being seized by the attorney that committed fraud in the action. And it's right here, clear as day, and it's a public record. And there is so much more fraud that every place you scratch the surface of this case, it gets worse and worse. And it's time for us to address this. It's time for this to address this as a state, because we cannot have a group of legal professionals operating at the very helm, policing themselves and deciding to run an organized crime ring against the public that is so bad that they're seizing houses into entire judgments and citing to fraud of their own officers as their pretext for doing it, which is exactly what happened here. Now, it's troubling to me that you don't want to hear that. It's troubling to me that this court's response is to not inquire as to what the fraud of attorney cashier was and not to address it.
My issue is, and maybe this will help, is that that's already been decided and it's been affirmed on appeal. What's before us is the validity of the alias execution. I know you feel otherwise, and I understand it, and it's very personal to you. I understand all of that
I don't
as
think
well.
it's personal. I think it's legal.
Well,
I think
okay,
as a matter
well,
of law,
well-
when you have fraudulent judgments that are, when you have a situation that's so bad that you have a payout of two judgments, the 1993 case and the 1994 case, and the state records disappear, and every time you go to the clerk's office, there's a different reason why there's no more record of the 1994 case, because the chair of the BBO decided to steal out the payout of that judgment with the cooperation of officers of the court. There should be no reason why that record of that case has disappeared. All those records should be maintained by law from 2000 in perpetuity. 2000 and back in perpetuity, it disappeared. It changed in the computer system from a settlement from a judgment to a settlement. And there is a record of is what happened in the federal court, which exposes how bad this is. And a state does not survive this level of corruption, and that's why I'm bringing it to your attention, and it should raise red flags. It should raise red flags for everybody, because you're literally not safe in your own houses. And the only reason why I'm before this court today is because she lost her execution, okay? But for that, I would have lost my house. And that's not a safe place to be for the citizens of the Commonwealth, to have their entire settlements stolen in violation of state court law, which protects them when they're on deposit with the court register by attaching millions and millions of dollars of interest in direct violation of state statute. This has got to stop. It has to stop, and if it won't stop, then if the court won't reconsider itself and stop itself, then it's going to have to be examined in the context of what the appropriate role for AI is in our courts versus the people, because we can't have a state that has $9 million payouts, cites to fraud of your officers of the court as the excuse to commit more fraud, which happened. It's not a question of material. It's not a reasonable question of material fact whether or not she committed fraud in her contingency fee agreement. It's not a reason. It's there in black and white. She made a non-party to the case a party to another action in order to try and steal millions of dollars, and she didn't get away with it. But you have us paying the price for listening to her legal advice that you can settle a case for any way you want. Well, that's not correct, clearly. That's not correct. You should be able to rely on the counsel of your attorneys and not have your home stolen by them. And taking $12.3 million on a judgment, reasonable legal fees, $12.3 million of legal fees on a $9 million judgment, which if you go back and you look at the actual record here, was the work for the insurance company work that proved that there was insurance coverage was done by a nonprofit out of New York and San Francisco. So you have the head of your regulatory agency taking credit for work in another case, in another action. You have taking credit for work that he didn't do because it was excluded. This isn't sustainable. It's not sustainable. And I will say, going back to this, I think that this is all relevant to whether or not this execution, you should exercise the equitable relief of this court in order to rewrite this execution, because I think that this underlying judgment and the behavior that is clearly exposed on the record is disturbing. I think it's disturbing, and I don't think that the equitable relief that she's seeking should be invoked given the facts of this case and the underlying record of this case.
Do you have an argument about why the firm's failure to maintain the original execution bars it from obtaining a duplicate original execution?
Yes.
Aside from your
Yes.
your complaint with the underlying merits?
With respect to that, I would say that with respect to the duplicate execution, she didn't move for a duplicate execution. She moved under a specific statute requesting an alias execution. I think attorneys should be required to know the law that they're seeking, that they're practicing, instead of having erasers on the back of their pencils for every kind of misconduct and misbehavior and error that they make. And I don't think that sitting judges should be spending their time redrafting legal fee agreements or inserting language into fee contracts or inserting or rewriting motions to give relief that is not available to them. Furthermore, she said that she didn't have a copy of this execution. Well, it's an intrinsically valuable document. The rules of professional conduct require her to maintain her documents. And the reason for it is because you can't have either attorneys or banks losing their documents, not knowing where they are. Where's your deposit? I don't know where we put the records for that. Where's your deeds? Where's your mortgage? There's a certain class of documents that require an extra series of care. And being humans in the world, you can't always meet that bar, right? Because we have acts of God, we have tornadoes, we have hurricanes, we have, the bank got ripped off, the servers all blew out, whatever happened. But in that exercising reasonable due diligence and care over your records, it doesn't incorporate, I don't know where the heck I put anything. And I think it's the fault of the sheriff's office, who didn't give it to me 5 years ago, but I don't know because I didn't look. And that's literally where we are with the fact pattern on this case. I think that she should have exercised more care in the settlement so you wouldn't know me. And I think she should have exercised more care in the keeping of her records so that you wouldn't have me here today. Thank you.
Thank you very much. Ms. Kasher.
Good morning. May it please the court, Dana Kasher for Krulowich Kasher, PC. The sole issue before your honors this morning is the propriety of the issuance of a duplicate original execution. Rule 69 says the process for enforcing a judgment for the payment of money is by execution.
What did happen to the original execution?
I'll tell you what I know.
Is your successor counsel?
No, I'm counsel.
Oh, okay.
It was obtained in a timely fashion from the court. It was sent to the sheriff's office with a request that they levy on real estate. The sheriff's office did levy, so they took it to the registry of deeds. I received back a return with, of course, a bill for the sheriff's services. I paid the bill and I put the papers that came back in a package from the sheriff's office in a file.
So that was in 2017?
That was in 2017.
But then then nothing happened until 2022?
Correct.
Why is that?
We didn't want to have to sell their house, Your Honor. There was hope that there would be some kind of voluntary resolution of this judgment, and there wasn't. So in 2022, I asked the sheriff's office to proceed to sale on the real estate, and they said, okay, but we need the original execution. I looked in my file, I didn't have it. They looked in their files, they don't have it. So somewhere between the registry of deeds, the sheriff's office, and my office, a piece of paper went missing. The piece of paper was issued in a timely fashion. It was issued in October of 2017, so the return date would not be until October of 2037. Chapter 235, Section 17 is written in the negative. An execution shall not issue 1 year after, and a replacement execution, after the date of judgment. A replacement execution shall not issue over 5 years after the return date. Well, Your Honor, we're not asking for anything during those time frames. The original execution was issued in a timely fashion in conformance with the statutes.
I couldn't see any affirmative language in Section 17 that authorizes alias executions. It says when you can't do them.
Neither 17 nor 19 speak specifically to alias execution, which perhaps isn't the word I should have used, but in practice, when these things happen, and from time to time these things happen, that's what we've always done, is file a motion for an alias execution to say a piece of paper has gone missing. But the substance of the judgment is unchanged. There's no challenge that nothing was ever paid on it. It was issued after a lengthy jury trial and then upheld on appeal. But for the statute denying the issuance of an execution within certain timeframes, it doesn't speak to issuing a duplicate, because a piece of paper was misplaced.
Right, and some states seem to have statutes that specifically address this problem when an original judgment is lost or destroyed. But I agree with you that Section 17 and Section 19 don't really seem to address this problem. 17 seems to deal with the need for a successive judgment where the original judgment wasn't fully acted on. So are you asking us to kind of fill in a gap not addressed by the current statutes? Or do you really think that Section 17 covers this situation as the judge seemed to?
To some extent, we are asking you to fill in a gap for these unusual instances where a piece of paper is misplaced. We're not asking you to do anything that the court hasn't already done, just to give another piece of paper. And Judge Ullman's order specifically said, with the same dates, same numbers, essentially it would be a duplicate of the original that was issued. And that's fine. That's what the sheriff needs in order for us to proceed. But neither of the statutes and any of the others that you refer to, or that were referred to by Judge Ullman, specifically state when the paper is misplaced, how that would be treated. However, I did cite a case in my materials where it spoke to the fact that, the failure to issue an execution in a situation like this essentially renders your judgment worthless, and that's not the intent of the legislature. I would point out Rule 69 talks about the execution being process. And other instances of process would be summonses or subpoenas and things of that nature, which you can easily, it costs $5. You can get another one. Because of the import of an execution, and I don't mean to denigrate that in any fashion, you can only obtain this by court order, which is why we went through this process. But where you have no question in the law as to the legitimacy of this judgment and the fact that it remains unpaid, it's appropriate that a duplicate execution issue so that that judgment can be enforced. Unless the court has further questions, I'll rest.
Seeing none, thank you. Thank you both. We'll take it under advisement.
Thank you.
The next case is 23P394, Wetzel versus Wetzel. Mr. Estes. Sit down.
May it please the court. To be perfectly succinct, it is the appellant's position that Judge McSweeney in this matter simply did not do his job. He just didn't do his job. And I know these are famous last words sometimes, but because of that, I think I'm going to be very short. The entire decision issued by the judge is 5 pages. So frankly, there's not a whole lot to analyze. He made no findings of fact relative to domestic violence to support his decision to award the appellee, Amy Lynn Wetzel, sole legal and physical custody of the children, and he utterly ignored the financial issues. The only financial issue he addressed at all was child support, which, given the fact that my client at the time subsisted on Social Security, it was inappropriate to even issue that order, which was the only financial decision he made. Obviously, under Master Law Chapter 208-31A, the court, in awarding sole legal custody, has to make a finding by a preponderance of the evidence that there's either a pattern of physical abuse or at least one serious incident of physical abuse. There's simply no evidence at all of that in this case. Obviously, the statute itself acknowledges that the existence of a 209A order is not enough. A finding by another court and another judge, that's not enough. The court has to, in a divorce case, has to make an independent finding of facts to support an award of sole legal custody. The clinician in this case, who did a thorough investigation, talking to both parties, talking to the children, uncovered a single incident of what you would call an altercation between the parties some years before, where the parties had fought over a set of keys. Indeed, in her brief, the appellee, Amy Lynn Wetzel, concedes that the judge made no findings of domestic violence and that his award of sole legal custody was based only on an inability to communicate.
Well,
I would suggest
there was an allegation that your client threatened to crash her automobile with the children inside, and that wasn't disputed below, right?
I'm sorry, I can't quite hear you.
There was an allegation that your client threatened to crash her car with the children inside.
Yes, there's an allegation.
That wasn't disputed below.
It wasn't disputed, although actually the way the judge wrote about it in his finding was that there was an allegation.
Yeah.
He didn't make a determination whether he believed that allegation. He didn't really say anything about it other than there was an allegation. But yes, Your Honor, there was an allegation that in 2019, some 3 years before this case went to trial, that my client had threatened to crash her car with the children in it, and then she ended up in a psych ward.
And the clinician documented substantial mental health substance abuse challenges, correct?
Yes, on both sides, although she also goes on to note that my client had taken a number of great strides towards addressing her issues and was stable, very stable at the time of trial. No suggestion whatsoever of any alcohol or drug abuse, no suggestion of any acute mental illness. It was all being treated. But the judge, I suppose, if you want to call that a finding of fact, he did adopt the clinician's report as credible, although during the trial he actually said, even though he's accepting all these exhibits, that doesn't mean he's going to read them, which I didn't know what to say when he said that. So I'm not even sure that he read it. I know he heard it at the trial because I elicited a lot of testimony from Ms. Westerbrook about her report. But he made no findings whatsoever about a history of domestic violence that would support a finding of sole legal custody. And in fact, as I said a moment ago, the appellee, Amy Lynn Wetzel, concedes that in her brief and says that the award was based solely on an inability to communicate. That, I would suggest to the court, based on the facts before the trial judge, is a perverse result. Because the inability to communicate, the testimony was that the appellee, Amy Lynn Wetzel, refused to communicate with my client. Never answered a single text message about the children, not one. And when she had custody of the children, she testified that she blocked her in all possible ways and never communicated with her. So to say that the parties can't communicate because I refuse to communicate, and then to give me sole legal custody is a perverse result. Her own misbehavior was the...
I see in your conclusion that you've asked that we make findings of fact and make alimony and child support determinations. That's not traditionally something that we do. Failing a departure from tradition, you're asking for a remand?
Yes, and asking for a remand to a different judge. I think given the egregious nature of his decision, warrants that we go to a different judge. And I know that I know I was reaching in asking for that, and I know that the likely result is a remand. It's almost always the result in a family court case. And certainly, well, moving on, the facts before the court was that the appellee here refused to co-parent. Jennifer Westerbrook, the court clinician, testified about how important it is for parents to co-parent, encouraged the parties to co-parent, and the appellee here simply refused to communicate on any level with my client, and for that was rewarded with sole legal and sole physical custody. Also, if you look at the evidence, the court ignored findings that would support an award in the other direction. There were clearly issues identified at trial that would favor my client having at least joint legal, if not sole legal custody. The appellee testified that she had such cognitive executive function disorder, such a serious cognitive executive function disorder, that she couldn't work. That should give any judge pause or elicit some question about the ability to parent. Certainly, parenting is emotionally and intellectually.
Did you seek an attribution of income?
Your Honor, I did, well, no. In my findings of fact, I did. What I suggested to the court is that everyone shows up to trial in family court broke. It's common. People show up, I've lost my job, I can't work, I can't pay. I tried to explore that. I issued a trial subpoena. The appellee refused to comply with that subpoena. The judge refused to order any sanctions in that regard. And I will acknowledge, I could have been stronger in my argument at trial. However, in my findings of fact and conclusions of law, that's exactly what I asked for. I said, do not credit this financial statement some 4 months later where she goes from making $120,000 a year to nothing. I also would note for the court that while the appellee says in her brief there was nothing to divide, at trial she acknowledged that she had simply made a mistake in her retirement account and there was still $40,000 in that account. So there was money to divide. And I think given what we established in terms of the marital waste, justified more than a 50-50 split. I believe that it justified my client being awarded the full $40,000. But of course, as Justice Hirschfang, sorry,
Right.
as you pointed out, the normal course here would be to remand this back to the family court for a determination of whether or not there was marital waste. We had a contempt on that was never rescheduled it was scheduled for an evidentiary hearing, was taken off the list, never rescheduled. Asked to consolidate it at trial. The judge said he doesn't consolidate contempts at trial. So I just raised it as an issue at trial, which is perfectly appropriate. And I don't mean to be insulting, but he just ignored it. There's not a word in his decision that discusses the money issue, the marital waste, the $40,000. So at this point, I mean, ideally my client would like the court to reverse custody, but I understand that the normal course would be to remand this to the trial court. I would also ask the court to award that $40,000 to my client because I think that's entirely appropriate under the facts. But again, if it's going to be remanded for findings of fact, that's the normal course. I understand that. However, given the egregious deficiencies in the court's decision, I would ask that you remand this to a different judge. We would like a shot at a judge, frankly, who is going to pay attention and is going to issue at least a thoughtful decision. I might not agree with it, but give me something to understand the reasoning behind his total denial in addressing any financial issue and ignoring the factors that he's supposed to consider in determining legal and physical custody for these children. I skipped ahead, but we did present a bunch of evidence about my client's fitness as a parent, pictures of the home, proximity to the schools, the neighborhood in which she lives in, the lifestyle that the children would enjoy. And in determining the best interests of the children, of course, that's something the court's supposed to be considered. On the other side, nothing like that was presented. No evidence whatsoever about the children's lives were presented. And the only factor that seemed to weigh in the appellee's favor was that the children had continuously resided with her for a couple of years prior to trial. But again, there were no findings of fact. So I don't know why the judge ruled the way he did, because he simply didn't explain it. So for all those reasons, I would ask for this to be remanded to a different judge for an order that's consonant with the laws of the Commonwealth. Thank you.
Thank you. Ms. Wetzel.
Good morning, Your Honors. May it please the court. My name is Amy Lynn Wetzel. I'm the appellee.
Can you just move that microphone closer to you? There you go. Thank you.
Good morning, Your Honors. May it please the court. My name is Amy Lynn Wetzel. I'm the appellee in this case. My understanding is that there are 3 questions to be answered here. Did the judge abuse his discretion when he granted full legal custody and physical custody to me? Did the trial judge abuse his discretion in ordering that neither party should pay alimony? And did the trial judge abuse his discretion with respect to division of the marital assets? And my additional understanding is that we have to ask questions like, did the judge do something wrong? Was there abuse of discretion or error in law? And did he consider something he wasn't supposed to consider, or did he fail to consider something he should have? And not necessarily would you 3 have done something differently. With regards to abuse of discretion when he granted full legal and physical custody to me. I believe that he did the job that he needed to do. I do believe that he considered the children's best interest. I believe the response that I had a legal person help me draft has done a good a job as I can do. I'll articulate now why I think he did consider the children's best interest. They wanted additional time. He increased parenting time, overnights, Zooms, vacation times, her access to information. All of those things were in response to the children's best interest. I believe that the shared custody, I never saw anything in the divorce that indicated domestic violence was part of his determination. I saw him referencing the restraining order as something that made it additionally difficult for us to communicate. But the court clinician, Judge McSweeney, and all of our times together saw that the two of us could not communicate effectively. There was a restraining order in place. She had legal representation. I represented myself, so I spoke to her legal team and did not speak with her directly. During that time, there was a restraining order in place from July 2019 until January of this year. But the court clinician and the Judge McSweeney cited our high levels of contention, animosity, and difficulty in communicating, and the great distance between us as being my understanding, as being the reasons, and the fact that they had been residing with me, and that it's best not to mess with the status quo when the children are there and thriving and have the stability and such. So there were other factors that he did, I believe, consider. And my understanding is that the Rosenberg versus Meridia says the determination of which parent promotes a child's best interest rests with the discretion of the judge, whose findings must stay unless they are plainly wrong. I don't believe that Judge McSweeney did anything plainly wrong in his determinations. The Supreme Judicial Court noted that stability in and of itself, or is of itself, enormous benefit to the child, and any unnecessary tampering with the status quo simply increases the risk of harm to the child. And if the parenting arrangement in which the child has lived is satisfactory and is reasonably capable of preservation, it is ordinarily in the child's best interest to maintain that arrangement, and contrary to the child's best interest to disrupt it. Our children are thriving. They have autism and have additional challenges. They are both for the first time last year, finally, we're thriving in their school settings instead of constantly being under-supported and unhappy there. They are engrossed in their community with viola lessons and swim lessons and dance lessons and Girl Scouts. Like, they are enmeshed in their community. Our son has struggled to make friendships. He has those connections and friendships now. Like, I cannot even fathom how devastating it would be to our children if she actually got what she wanted, which was full custody. So I ask that the court not disturb the status quo with our children. I think that's about what I wanted to say regarding the children. Did the trial judge abuse his discretion in ordering that neither party shall pay alimony? Her lawyer does not paint a very good picture of me in suggesting that I stopped working intentionally just to avoid paying alimony and such. I am a veteran. I'm a disabled veteran because of the cognitive disabilities that I incurred that are service-related, that got worse. I was unable to perform the functions of my job. This was a very slow and steady downhill thing, and it just happened to culminate that when I stopped working and when the VA was helping me, it just happened to be during the court time. And that's unfortunate, but I didn't, my point is I didn't have the ability to pay. I forget what my income was. It said somewhere, it was like $1,000 and something. My rent, it didn't cover rent, and I have children and more than just rent as far as to cover all my monthly expenses. So I had no ability to pay. So I don't think the judge made a judgment in his error in his judgment or did something that was plainly wrong when I had no ability to pay, and he didn't produce any evidence that would suggest I did. Did the trial judge abuse his discretion with respect to division of the assets? My understanding is that the lawyer's testimony is not evidence, and the only person that said there was $40,000 in that retirement fund was the lawyer. I didn't and don't know how much is in that retirement fund. I admitted that I made a mistake. I had a lawyer in January for a little bit that had submitted something And all the times I had represented myself and filed a financial claim, I never knew I was supposed to be looking at retirement stuff. I thought it was only money that I had access to. I didn't fully understand what he was talking about during the testimony I was given, but I just know at the end of the day, there was no evidence of that $40,000, and it was on the lawyer to press the issue and get evidence to show what amount, if any, was in the retirement so that the judge had something to consider. He failed to do that, so therefore there was no evidence for the judge to consider, and therefore he didn't make any, he didn't do anything plainly wrong.
You did testify at trial, Ms. Wetzel, about your TSP account.
Yes, that's the retirement we're talking about.
Yeah, and about having withdrawn some money.
Yes, ma'am.
From it.
Yes, ma'am. And
what you're saying now, if I'm hearing you right, is that that's the evidence we have in front of us about your retirement funds.
So I really wasn't understanding during trial what was going on. To me, in my brain, there were two different pots of money. My retirement contributions that my employer put in for me that I wasn't allowed to touch, and my own contributions that when we needed it, we had taken out a loan on it and I was repaying that back. I knew of this one. I didn't know what this one was. He was talking to this one and I was talking to this one, I think, during trial. So what is in this, that the employer contributions of my retirement, I don't know. And that's what I think he's wanting considered is the judge didn't rule on this when there was no evidence of this or the amounts. But I have a better understanding that I did the day of trial. The day of trial, I only knew of my contributions as far as like what I thought was up for grabs, I guess. I did want to make, I guess, I've said that there was no domestic violence. I've mentioned that there was a restraining order, and that's why we weren't communicating. I was communicating through her lawyer. And just also during the time that the court clinician stepped in, she spoke to the same therapist that was there before I left while I was still in the picture. So the whole chunk of time that that Keeley was getting better and that the court clinician was relying on the fact that she was seeking the help she was supposedly seeking. There's no mental health therapist that saw her during that entire chunk of time from July 2019, or maybe September 2019, up until around February, the same month that the court clinician came in. Then she went back to the same therapist she had been seeing while we were still a marital unit. And the reason that concerns me is that while we were a marital unit, this same therapist in 3 separate DCF reports said she didn't think alcohol was a concern for Keeley. Meanwhile, there were multiple Section 13s and hospital visits where alcohol was clearly a factor. She had wrecked and driven her car, drunk and drive, hit a deer, said she didn't even know she had hit a deer, but had totaled our car, so she hit a living creature, didn't know what she hit and kept going, or knew she hit something and kept going. Like, it's just either way, I have concerns based on a lot of things about her behavior, and supposedly she was getting better, and there is not one professional during that entire time that she was getting better to say they agree that she was getting better. The court clinician talked to the same therapist that had not seen her during this entire time that she had returned to just before the court clinician sets in. And so that is why, I just have concerns still, but at the end of the day, the judge's ruling must stand unless they are plainly wrong, and I hear a lot of him saying that Judge McSweeney did something wrong and hoping that Judge McSweeney did something wrong, but I don't see where he did anything wrong. I think that he considered what he needed to consider, that he did the job that he needed to do.
Thank you. Thank you both. We'll take it under advisement. Our last case is 23P 1124, McCarthy versus Young.
Thank you, Your Honors. Have a nice day.
Thank you.
Mr. Stetson.
Good morning, Your Honors. May it please the Court, Robert Stetson for the Youngs, the sellers in this case. I'd like to make 4 points. The first is that the OTP was an unenforceable agreement to agree because there were material terms, namely the access easement, that were not agreed upon at the time it was fully executed. Number two, if you disagree with that and think it was enforceable, the deadline to sign the P&S expired on January 21st. The seller's attorney preserved that deadline through his written communications. Number three, if in the alternative, the deadline to sign the P&S expired on January 29th by virtue of the seller's broker communication reestablishing a new deadline of that date, which was not met. And number four, under McMahon and Gallipol, the special motion to dismiss in this case should have been allowed because the buyer omitted the material facts about the pre-OTP discussions of the easement.
On the special motion to dismiss, you didn't appeal that within 30 days, did you?
No, we did not.
Yeah, so on general, Chapter 184.15 and Chapter 231.118 says you have to appeal the denial of a special motion to dismiss within 30 days to a single justice of this court. If you don't, we don't have jurisdiction to hear it after that period. So isn't that a problem?
My understanding is that we had the opportunity that the allowance of the motion would have been appealable or mandatorily appealable within 30 days.
It's a pretrial issue, right? And it's about the lis pendens period but now we have a final judgment that you all kind of put in motion. And so the issue is kind of moot in any event, but I think that you have a jurisdictional problem with respect to that part of the appeal.
Thank you, Your Honor. We didn't want to take a piecemeal appeal here, and so we made the decision to appeal all the issues after the final judgment was entered.
Okay. Well, let's address the summary judgment ruling that turned into the final judgment.
Thank you, Your Honor. If I could start by speaking to the OTP itself. The primary issue is whether or not there was a present intention to be bound by all the material terms of the deal. Was there a meeting of the minds? And the issue with the OTP is there was not. And there was not for three primary facts. Number one, the parties agreed before the OTP was finally executed to leave that term open, to let the lawyers address it. That's what we found from the buyer's texts with his broker. We'll discuss it during the P&S negotiations. That was put out there beforehand. And just like in Nelson versus Rebello, where there was a similar understanding with respect to a broker commission term, this court found in that case the OTP was unenforceable.
Why did your client sign the OTP after they raised the issue about the maintenance easement with the buyer? That's the problem here, right? You flagged the issue, and it goes to, the judge found that the buyer knew about it. But after that, then Trustee Kate signs the OTP, and that's when it takes effect. So I'm just trying to understand, what were your clients agreeing to at that point after they had raised this issue about the maintenance easement? They nevertheless went ahead and signed the OTP that had all the terms but not the maintenance issue. So you say that's unenforceable. What were they doing? Why did they sign it?
They signed it for the same reason that a lot of letters of intent are signed, to sort of form the structure, the framework of the deal. And as the late Justice Cass stated in the Gorin case itself, there's commercial utility to allowing parties to hug before they marry. And that's what we have here. We have, a level of understanding that, at least as to the things that are identified in the OTP, the parties aren't going to renege.
Well, let's just assume that your clients gave up on the maintenance easement. They said, that's actually not a big deal, we'll work it out. And then the buyer tried to back out. You would have been able to enforce the OTP against the buyer under the terms that are set forth there. Isn't that correct?
No, the OTP was unenforceable as to both parties because there was not a present intention to be bound when it was signed. Because the parties, both sides agreed. In a lot of the cases in which this court has found the GBRE form to be unenforceable, there was only one side didn't have a present intention to be bound. Here, we have both sides agreeing that there was not a present intention to be bound. Both sides agreed.
Yeah, but this case seems a little bit unusual in that your side, the sellers, were the side that had the issue that they cared about. Nevertheless, they went ahead and put the OTP into effect. That seems a little bit different from some of those other cases where, for example, the buyer says, well, in fact, even though I didn't put in the OTP, I have all these other sort of demands that I'm going to raise later in the process. And so there isn't a meeting of the minds there. But there does seem to be a meeting of minds as to the terms set forth in the OTP. I acknowledge that both parties anticipated that they would continue to discuss the maintenance easement, and they did after that. But I just don't quite understand your point that the OTP was completely unenforceable at the time your client signed it, given that they knew about the issue that they still wanted to negotiate on.
The Nelson Rebello is a perfect example of this, where you have a seller who thought that based on the pre-OTP discussions that the buyer was going to unusually pay the broker commission. And they went ahead with the OTP anyway. But what this court said was there was no meeting of the minds because that was a material term that they hadn't agreed upon. And I think Blomendale is another good example, where just the post-OTP discussions about implied warranties and what was going to happen show that at the time of the execution of the OTP, there was not a meeting of the minds. We have both. We have pre-OTP and post-OTP showing there was not a meeting of the minds at the time. And in the lower court got it right for the most part when it said this was a Blomendale type of agreement. He was right. This was a Blomendale agreement because, going back to Rosenfeld, it contemplated a future writing. So the strong inference, dating back almost 100 years, is that when, especially in real estate sales, when there is a contemplation of a future writing, that means that you don't intend to be bound until that future writing is signed.
Right, but the judge says, well, sure, this is a Blomendale type issue, but nevertheless, the OTP imposes obligations on the parties, including the obligation to try to reach a P&S by the specified deadline. Do you disagree with that?
Absolutely.
You disagree with that?
I disagree with that. There is no authority or case law in Massachusetts that supports that position, that an OTP that is unenforceable on its face imposes some kind of obligation or duty to negotiate. Now, and that is also not an argument that was ever made by my brothers, that there was a duty to negotiate. If that had been made, this would be a very different case, because for a few different reasons. Number one, it's not clear that an agreement to negotiate is enforceable in Massachusetts. I think under Schwanbeck, maybe. But number two, the duty to negotiate only requires good faith negotiations. We have that here. The buyer agrees that the sellers negotiated in good faith. They just didn't get a deal done on time. And number three, specific performance is not available for a violation of the duty to negotiate. You can maybe get reliance damages if there's been a breach based on bad faith conduct, but you wouldn't get specific performance, which is the type of relief that was sought here today.
One of the things I find difficult to track in your argument is you make a lot of points about the time of the essence clause and sort of how that wasn't complied with. But that's a term from the OTP, right? So is this an argument in the alternative, or do you actually see the time of the essence clause was effective?
Oh, no, that is entirely in the alternative, Your Honor. Absolutely. So what we're basically saying is, no, we don't under any circumstances believe that this OTP, as written, was enforceable. Which is, by the way, what the buyer has said all along, is that the OTP as written was enforceable. The judge disagreed with that. The judge didn't enforce the OTP as written because there was no meeting of the minds. There was no agreement. What the judge did was he sort of plucked, a term from January 27th in an unsigned P&S and kind of superimposed it on the OTP from 2 weeks earlier.
It seemed. Oh, go ahead. I'm sorry.
No,
I've
keep going. You know what I'm going to ask.
Well, no, it seems like my understanding of the judge is, there actually was a meeting of the minds, that the parties eventually agreed on the 3-foot maintenance easement that's set forth in the reservation. Maybe it's not finalized in a P&S, but between that and the general agreement of the terms set forth in the initial OTP, you have a fully formed meeting of the minds, and therefore that's the deal. Am I misinterpreting what the judge did?
I don't think you are. I think what the judge was looking at this from, the perspective, I think, from people that weren't involved in this transaction. You look at it and you're like, hey, you know what? They got close enough. Yeah. And so why don't they just go forward and do the deal? But I don't think that gives enough credence to the fact that, these buyers felt like they were being bullied by, or these sellers felt like they were being bullied by the buyer. They felt like he was ignoring them, that he had made numerous misrepresentations. So they had good reasons to pull out when they pulled out. That doesn't change the legal arguments, though. Under the case law, I mean, Nelson Rebello is right on point from this case. The OTP was not enforceable. Now, assuming that you disagree, in the...
Can I just pause you for one moment there?
Yes.
Because Justice Toon's most recent question approached but didn't quite get the thing I've been trying to figure out, which is, what was enforced here? Has the place been sold?
No.
Okay.
No, we've been, because of the lis pendens.
So Judge Vey made an order that there was an enforceable contract, right? And and ordered specific performance. Specific performance of what?
So what the judge said was the OTP was enforceable with the easement term that appeared in the unsigned P&S from January 27th. So he sort of Frankensteined this agreement based on what he thought was fair, because the parties almost got there. But on the law, they didn't. They did not get there.
Well, I don't even want to talk about the law right now, which is a weird thing for a judge to say, especially on the bench. But I'm just trying to figure out practically, right, this is a contract case. What is the contract? And you're telling me there isn't one. Am I right about that? I mean, not just arguing there isn't one for the reasons, but like if I were to look for the piece of paper that the judge said is enforceable, I wouldn't find that piece of paper because it does not exist.
Absolutely,
Okay,
100% correct. But if I could get back to Justice Toon, your question kind of went to the waiver issue, which we do argue in the alternative. Yeah. And I did want to just spend a minute, I know my time is running down, I did want to spend a minute on that issue, because the deadline, if the OTP were enforceable, the deadline is important, unless it's waived. And here, the lower court judge found that there was an implied waiver. In order to get there, there's got to be unequivocal evidence of an intentional relinquishment of right. It cannot be accidental. We don't have that here for two primary reasons. The first is that the parties agreed to extend the deadline from January 19th to January 21st with, quote, time remaining of the essence. That shows intentionality with respect to that deadline, that they were that there was something to be observed.
Not to cut you short, but they keep going after that, right? I mean, that's the judge. The negotiations keep going. Everyone seems to be like trying to get a deal, right? And the judge says that's enough to affect a waiver even beyond that second deadline, right? And so that seems more in the realm of the judge analyzing the factual record. I'm not sure we're going to be able to second guess that determination.
Well, it's summary judgment, so
Okay.
it's de novo. But in terms of that finding, what he completely ignored or glossed over was what happened on January 21st, which was the date of the new deadline. And the seller's attorney is reaching out throughout that day. How are we going to meet? How are we going to find a compromise here? No response, no response, no response. Before the deadline expires, he says, look, if we don't get an agreement or formally extend, neither of which happened, the deadline's going to expire. That doesn't mean that we can't try to put in his words, try to put the deal back together next week, but we're not going to be under contract. That's what happened. And that's Parencello, Your Honor. Because in Parencello, there was advance notice, just like there was here, of that deadline. That shows intentionality with respect to the deadline. And that puts those post-expiration discussions in the proper context. There wasn't an intentional relinquishment of rights. Contrast that with McCarthy. McCarthy is a great example. There was never any formal extension. There was no reference to deadlines at all. And importantly, as this court focused on in Ream, which is a 128 decision, but it talked about this issue, the seller didn't even provide the P&S until after the deadline. So that made it, because it was the seller's responsibility in that case, it made it impossible for the buyer to comply. So if you're looking, well, who's at fault?
We're going to have to leave it there. Thank you.
Thank you, Your Honors.
Mr. Clifford.
May it please the court. Scott Clifford, I represent the plaintiff, Gregory McCarthy. We're here today to ask this court to affirm Judge Vay's decision as it relates to the summary judgment based on the comprehensive decision in the summary judgment record. I disagree with my brother, no surprise there, with respect to the fact that Judge Vay did in fact find that this was an enforceable contract between the parties.
Can we just go to Justice Hirschfang's question? What is the deal? What is the enforceable? What do we look at and say, oh, okay, this has to be performed? What exactly? It does seem like a little bit Frankenstein. It's the OTP plus the terms and the reservation that was never actually formally approved, but it was a meeting of the minds. Is that the contract that?
I believe it is, Your Honor. You have the four corners of the offer to purchase itself, which contains all the necessary material terms for our contract, and then Judge Vay took the agreed-upon language that had been, as Your Honor points out, negotiated over several days from the agreed-upon purchase and sale agreement that the defendants refused to sign, and took that language that they wanted and found that was the meeting of the minds with respect to what was enforceable and what the plaintiff could seek for specific performance.
So just going back, one of my problems with your position here is that you seem to argue below that the OTP was the deal. And the judge disagreed with that. He said, no, that's there, because there was this easement issue out there. It wasn't. It was a Blumenfeld, is that the right
That's correct,
type deal. Nevertheless, it imposed certain obligations. So then how do we go forward and sort of say, we get to the point where there's a meeting of the minds as to the easement. We go back to the OTP and say, okay, we're going to take all those terms in this agreement and import them into a final contract. I don't quite understand where the judge ended up as to what the OTP means from a contract standpoint. Do you understand that?
I do. And I think if you, in reading Judge Vay's decision, I think Judge Vay was saying is that the purchase and sale agreement that the defendants refused to sign its basis is found in that offer to purchase. And in addition to, as pointed out, and one of the problems that we had at the lower level in terms of this case was the issue of, and pointed out by Your Honor, is that the defendants had the opportunity, took that opportunity to have the offer to purchase reviewed by their counsel. And in fact, as indicated by the summary judgment record, the counsel recommended and suggested and indicated that he was going to submit language to include in the offer to purchase with respect to this maintenance easement that they said they needed. So the question then becomes, well, they chose not to take that advice and insert any language in it. They accept the deposit, and then they execute, the second trustee, that is, executes the offer to purchase, and now we have an effective agreement that's in place that's undisputed by the parties. Bringing us forward, we then look at what transpired over the next several days. In fact, it took 17 days from January 10th, when the offer was first submitted, to January 27th, and we look at what took place during that time. And one of the issues that was raised at the lower level and then raised on appeal by my brother is with respect to this time of the essence. And the contract, as the offer to purchase, that is, as extended by the parties, supposedly expired at 6 p.m. on January 21st. But what we have to focus on, and I think Judge Vay did focus on this issue, and as opposed to what my brother said, and said he ignored the context of that email that was sent on 5:33 p.m. on January 21st, is Judge Vay did analyze that, and he said, in fact, then there was an offer to extend. And then what we look at is what happens over the next several days.
Yeah, okay. I'm sorry to interrupt you. I just want to go back to, I understand where you are with respect to the OTP, because as I understood, you argued below the OTP is a contract, it's an enforceable contract, right? And even though the parties knew about this other issue, it wasn't, the seller signed it, and so if that issue couldn't be resolved, the OTP was still enforceable. And the judge disagreed with that. He said, no, it's a Blumenfeld type agreement. but nevertheless, it's in some way enforceable. So I guess, is your position that you agree with that ruling? And if so, what does that mean? Because I think the sellers make a good point that there is no precedent that sort of talks about a Blumenfeld-type agreement nevertheless being imposing duties on the parties. And I'm just trying to understand what exactly comes out of the OTP process.
Well, Your Honor, I think you have to, when you look at it in the context of the entire transaction, is that you ask the question, and I think it was a right question to ask, is what does the offer to purchase mean then? Because it's not a reservation of rights. It's not as suggested, a letter of intent with this agreement to bargain later on. It's a document that contains all the essential terms with respect to this agreement. And I think what Judge Vey focused on is he said, okay, subject to the parties' obligations, according to the offer to purchase, to negotiate a mutually acceptable purchase and sale agreement. Tucked within that, I think Judge Vey said, okay, this issue of this maintenance easement that was requested by the seller after the offer to purchase had been submitted by Mr. Carthy, after the offer to purchase had been signed by Mr. Young, that term is tucked into the subject to the mutual agreeable purchase and sale agreement. And that's what transpired over the next 15 days, was the parties negotiating that purchase and sale agreement that included the language that was requested by the defendants, that being specifically the maintenance easement. And so Judge Vey found that writing was sufficient with respect to the agreement reached on January 27th and should be enforced. And specific performance should be awarded to the plaintiff, assuming, as indicated in the decision, the plaintiff could show that he was ready, willing, and able to perform, which was subsequently agreed to by the parties, and that's the reason the judgment was entered. In terms of the issue of waiver, Your Honor, I think it's clear from the facts of the case, especially as written by Judge Vey, that the parties did continue to negotiate as they had been negotiating previous to January 21st. We see that in the undisputed material facts in the summary judgment record, including starting on the morning of January 24th, there's an email exchange and communications with the seller's attorney, seller's broker, and the sellers, where they're not talking about the fact that we're not operating under any type of agreement at this point in time, not that any type of agreement had expired. They're discussing what it is that we actually need in order to make this easement work for us to be able to sell the property to the plaintiff in accordance with the agreement that was previously reached. Later that day, we then get the seller's attorney emailing the buyer's attorney saying, listen, we've discussed it. We've finally been able to figure out what we need, and what we need is a 3-foot easement. And if that works for your client, let us know by tomorrow. The importance of that, in my mind, and I think as Judge Vey put in his decision, is the fact that this was the seller's attorney, unsolicited, reaching out to the buyer's attorney to continue the negotiations with respect to the contract and the purchase of the property, in addition to the fact that showing that time wasn't of the essence, says contact me tomorrow. Then we see from the record that in fact Attorney Hurd, representing the buyer, contacts the seller's attorney at 3:02 p.m. the next day and says, my client's agreed to the 3 feet, here's the revised purchase and sale agreement reflecting that 3 feet, and then subsequent to that, he's asked to make a change, he makes a change. But if we fast forward then to January 26th, I think the important issue is that on January 26th, the seller's broker then sends an email to all the parties involved saying, listen, we've been almost extended a week now, we need to get this agreement signed. It's not necessarily the importance of the fact that she says we're extended a week now, but the seller's attorney had an opportunity at that point in time to set the record straight. If there wasn't a waiver of this time is of the essence, the attorney certainly could have raised it at that point, even though there was tons of communications previous to that where he could have said, listen, we're not under contract, the contract is expired. He doesn't say any of that. And when the seller's agent sends this email on January 26th, he doesn't correct her and say, we're not under any type of extension. We're not even under contract. No, he just continues as business as usual. So if, in fact, there wasn't a waiver at that time, certainly he could have corrected it. So it's our position that, in fact, the time of the essence clause within the offer to purchase was waived by the seller's actions as indicated in the case law that's been cited by both parties. And then, in addition to that, I'd just like to point out that as it related to the suggestion by seller's counsel that you could then restore this time of the essence by sending an email on January 28th, first, there's nothing in the summary judgment record that indicates the selling agent had any authority to make any such restoration in terms of time as the essence. But more important than that, as indicated in the case law, she didn't, nothing in there, not anything in the January 29th communication from the seller's attorney contained the requisite elements that is expounded in the case law, that being that it had to be definitive notice, reasonable time to perform, and then what was going to be the consequences if you did perform. So in fact, we think that based on that, that there was sufficient evidence as found by Judge Vey.
I'm still unfortunately a little stuck on the OTP, so with your remaining time, what's your answer to my question to your brother about if, just based on the OTP, if the buyer had tried to back out of the deal, could the sellers have enforced the OTP, forget about the maintenance season, and just try to enforce the OTP against the buyer?
I believe the seller could have, and this because they had all parties, all the necessary requirements were met. All the necessary parties signed the document. The deposit was made. At that point, we were bound, and our intent was to be bound.
And what is your response to the judge saying, well, there wasn't an integration clause in the OTP, so therefore you can't say it was a complete agreement between the parties?
Well, Your Honor, I think that in terms of the practice, in particular of real estate law, is that this is the document that is always used. And the same document that was used in McCarthy v. Tobin case. And the fact that there was no integration clause, I still think you have to come look at the elements with respect to what is required in the contract, and all those elements were in place. Therefore, again, I go back to the fact that I think Judge Vey was correct that it was, well, he didn't use the term enforceable contract. He used that there were obligations that made it enforceable with respect to the parties, and he was referring to the fact that they had to continue to negotiate this purchase and sale.
Do you agree with his characterization in the footnote that this is a Blumenfeld-type agreement?
I'm a little bit troubled by the fact that the sellers had the opportunity to insert this language in the offer to purchase and then chose not to. And, you know, we seek counsel gives us advice, and then we seek to ignore it, and then later on rely upon verbal communications. And, you know, when you're dealing with real estate, everything is supposed to be reduced to writing. So it's a little bit, that's what caused me a little bit of trouble in terms of that aspect of Judge Vey's decision. But ultimately, I think Judge Vey is correct when he looks at the entire sequence of events that took place in this case.
So this may well be somewhere in the record, and I apologize if I didn't find it, but what is your client looking for?
Our client is looking to purchase the property and give the seller everything that they were expecting. That is the purchase price and the 3-foot easement, quite frankly, they were looking for. That's what the plaintiff is willing to do, is asked to do, and wants to do. Just meet the seller's expectations and provide those things. The only other thing I would add with respect to this is the fact that, again, it's our position that the time of the essence clause was waived. It was not properly restored by the sellers. The buyer then tendered the purchase and sale agreement, tendered the required deposit, and we just ask this court to affirm Judge Vey's decision as it relates to the summary judgment that I think, in reading his opinion in its entirety, it is thorough, it's thoughtful, and it's supported by the undisputed facts in this case. If there's no other questions, I'll rest on our brief. And thank you, Your Honors, for your time today.
Thank you. Thank you both. We'll take it under advisement. With that, I'd like to thank my colleagues, our law clerks, our court officers, our clerk's office, and our excellent timekeeper, and we'll stand